morning. We're here on the Pro Se Family Law Docket A for March 1st. I'm Kyle Weiss, Dave Nelson, Carissa Schumate.
Here.
Schumate's here. Is Kyle Weiss here?
Yes, present.
All right, good morning. Mr. Weiss, I believe this is your motion for contempt. And so why don't you go ahead and present your case?
Is the GAL assigned to our case, Beth Bellows, present?
I haven't seen her yet. If she's important to your case, then we can pass it and go on to the next one.
I believe she is. This is why we set it over from last week. She had some input on it, but yeah, I believe she's important to the case.
All right, I don't see her and she's not in the waiting room. So let's
Sounds
pass
good.
it. Okay. Shauna Ray and Jason Chappelle, I think both of them are here. I think last time we were here, I had required a UA would be completed by February 10th, and I haven't seen the results of that. Were you able to do that, Ms. Ray?
The results should have went to Mallory.
And maybe they weren't filed with the court. Were those provided to you, Ms. Smith?
I am not aware that those results have been provided to me. I can check through were they sent via fax or email, Ms. Ray? I'm
sorry, Mallory. They were sent, as far as I knew, email. I could not find your fax number that you gave me.
Okay.
And they didn't have your fax.
Okay. Okay, so I do have the results, Your Honor. Would you like me to file these with the court today, or would you like me to forward them to you? I'm happy to do either or.
Well, why don't we discuss what they are now? What do they show?
Okay. We have positive for cannabis use, it looks like. Oh, patient negative. My apologies. Yep. So it says on 2/24, submitted at 4:38 p.m. Patient it's negative. Shauna Ray's signature, and then the office manager.
All right. All right. Thank you for getting that completed. I guess the question is this. There's now been a minor guardianship action filed by Jessica Chappelle that we're all involved in, that I'm dealing with trying to create visitation to Ms. Ray. And I'm wondering if this case in the family law court should in effect be suspended, so we deal with everything in the minor guardianship action. And Ms. Smith, what do you think of that proposal? And I'll let the parties comment about that.
So I think that it is most appropriate for us to evaluate the minor guardianship. I think that it's no surprise that one of the parents is in agreement with
in there, and I just don't see her.
Let me mute this person. Go ahead.
So one of the parents is in agreement with the guardianship. One of the parents is not in agreement with the guardianship. So statutorily, we need to evaluate whether it's even appropriate for Miss Overby or Chappelle to gain guardianship, even on an emergency basis, or a full minor guardianship. And then addressing the specifics of this family law matter don't appear appropriate at this time, given the full or the guardianship case that's currently pending. I think it would create a little more confusion for the parties than assisting and moving forward.
Okay, thank you. Ms. Ray, any comment?
Yeah, of course, I'm gonna agree. I think that the case with Jason, if that's what the question is, that I'm understanding, if this new case with Jason needs to be suspended, is that what I'm getting?
Well,
Like-
till we figure out what's going on in the minor guardianship case.
I think that it shouldn't be Miss Chapel having an option to get guardian for the children. It should be me or Jason. And I feel that Jason has a couple times now neglected and abandoned his children.
Who's outside? I don't know. I'm doing something. I'm sorry.
I'm muting them now. Okay. All right, I understand your position on that. Mr. Chappell, any comment?
Yes, Your Honor. I would like both of the cases to be combined. I have not neglected or abandoned my children. And Miss Overby is more than capable of taking care of all the children's needs, so I believe she's able to navigate the court system just fine and be able to deal with whatever comes her way.
So, Ms. Ray, in the minor guardianship matter, you will be able to argue that Ms. Chappell should not be the minor guardian. And by what I'm about to do isn't going to take that away or take your argument away on that. But I think in terms of how these cases move along together, we need to determine whether the minor guardianship is appropriate. If it's not, then we need to come back to this case and figure out what the parenting plan will be for the children. If it is appropriate, then that probably is going to govern how the kids will be cared for in the at least immediate future. Is put it over to May 3rd at 9 o'clock. That should give us enough time to address the minor guardianship petition.
Is there?
And I'm not sure when the next minor guardianship hearing is, but I suspect it's in a couple weeks. And we'll be moving forward on that.
I haven't still heard from Mr. South, Timothy South.
Have you tried to call him yourself?
I have spoke with him, but as
Okay.
far as us communicating, I've only spoke with him a couple times, and he's like, he's gonna get into the case and read it. And I don't hear from him, so I call him again. I'm gonna get into the case and read it. And right now I'm stuck with, haven't heard from him. So I'm gonna call him after here. I don't know which.
Call him right now and at least leave a message that there's a hearing next week.
Right.
All right, so thank you for, again, doing the test. I'm glad it was negative. I'm going to put this over to May 3rd at 9 o'clock, but we'll be dealing with the minor guardianship proceeding in the meantime. So I will probably see you back here next Tuesday. All right, again, it's your motion for contempt. So if you want to go ahead and argue that, and then I'll hear from Ms. Shoemate, and then I'll hear from Ms. Fellows after that.
Me and Miss Shoemate have an existing order. And some of the motions in that order are Taylor's social media accounts were to be removed off of the internet. That was 15 months ago. They're still up. Another one is Taylor was not supposed to be introduced into any men, any new lovers until they have been dating for at least 6 months. What was the other one I was doing here? When Taylor's being transported for drop-offs, if somebody that is unknown to me is transporting her, that is driving, I am allowed to ask for insurance and valid driver's license. This happened on December 25th at a drop-off. I requested it. Miss Shoemate denied me that ability. Her initial response was, and this is through text message, I do not have to provide that to you. And then she provides a statement to the court that says, oh, he wasn't comfortable giving it. So she gave two different stories. As far as the social media goes, there's a very inappropriate video of my child that's been on the internet for quite some time now that she was told to remove. And it is a video of my daughter when she was younger twerking on a camera with material stuffed in her butt to make her butt look bigger. And she was unsupervised making this video. And then as far as the new boyfriend, on December 25th, when I pulled up to pick up my daughter, Carissa Shoemate denies that that's her boyfriend, but I saw those two smooching as I pulled up. So I began taking pictures. Taylor has informed me that she sees kiss and smooch all the time. Miss Shoemate spends a lot of time with Vince. Every time she calls to speak to her daughter, she's at Vince's house. And then there's a picture of Carissa's Facebook. She's in Vince's bedroom wearing his clothes. So she thinks she found a loophole of, oh, we're just going to say we're not together, and then we avoid it. I don't think that's okay at all. And I believe those three matters were it on the contempt.
What social media site is this video on?
TikTok.
Yeah.
Taylor has her own TikTok account, and it still exists. She also had an Instagram. I don't believe she had Facebook, but she was ordered to remove those, and it's been at least 14 months now. They have not been removed.
Okay, thank you. Ms. Shoemate, do you have a response?
What was that?
If you would like to respond, you can do that.
Yes. Vince is somebody, we're taking it slow, so we're just being friends. And the TikTok and the Instagram, I tried to remove, but I no longer have that number, so I can't. I'm trying to figure out how to remove them. And I've never kissed my, Vince in front of my daughter at all.
Would your daughter be able to remove it since it's her account?
Well, I'm the one that helped her and used my number. So it was an old number, so I'm trying to figure out how to go around that.
What about the failure to provide the insurance and the driver's information?
He said that he will provide it to you guys. He didn't feel comfortable giving it to Kyle
Why was that?
because he doesn't know him. And it has all his personal information on it.
Your Honor, can I address that?
Not right now.
Sounds good.
There is a requirement, however, that anybody that drives, that Mr. Weiss can obtain that information. Do you agree with that?
Yeah, I seen it when he sent it to me.
Okay. Anything else?
No.
Okay. Ms. Fellows?
Yes, Your Honor. I haven't really been involved in this case since December of 2021. I did file a report and the court did agree with my recommendations to change the custody to the father. So I don't know a lot about what's going on except what has been filed. What I can say is that it has been concern about mom moving frequently. Excuse me, and she has moved again from the place where I knew that she was up in Rochester. She said to me when I asked her that she moved about 10 months ago. So she is in the local area, in the Longview area right now. The boyfriend, Vince, that has also been a concern throughout the time that I've been involved, is that she does get involved with different males, moves in with them, then breaks up, because she was living in Rochester with her boyfriend Reggie and his mom. I don't know why things broke apart there, but now she's with this Vince. To be honest, with the history that I know, I would find it very disingenuous to say that she's taking it slow, because generally she jumps in and moves in and is in a relationship very quickly. And it does say that she's supposed to wait 6 months before introducing any kind of love interest or anything of that sort to Taylor. So the fact that Taylor knows about Vince is said, you know, that she's seen her mom and Vince kiss and things like that, leads me to believe that there's more to this relationship. The social media, that is a concern. Not sure why mom can't be able to shut those down.
All right. Mr. Weiss, you have the last word if you want.
Yes.
Go ahead.
As far as Vince goes, I have a pretty good idea, and I got some information that I will provide. I just found this out recently. I believe she did not provide the driver's license because at that time, Vince had active warrants for his arrest. Since our court date last week, he has been arrested twice and currently has 11 pending charges, including domestic violence and threatening to kill somebody. I don't want this man around my daughter at all. I'm pretty sure Carissa Schumann is aware of this situation and still has intentions of bringing him around my daughter. I want something done about it if we can. As far as the social media, if Carissa had shown or proven some type of evidence she tried, like she had texted me and said she tried, or she got a hold of somebody and said she's trying, she can't figure it out, I think that'd be a little more believable. But I've seen no effort as far as evidence goes, as she's been trying to remove them. She knew she was supposed to remove them, and there's just been no effort.
All right, thank you.
That's all I got to say.
Your Honor, I would like to ask, what is Vince's last name?
Okay, Mr. Weiss has brought forth 3 potential reasons that Ms. Schumann is in contempt. One is that their child was in a vehicle driven by someone. He asked for the name of the person and proof of insurance, and also their driver's license number, which is was provided for in a previous order. Through text messages, that was not provided. It's insufficient to say, well, he'll provide that to the court now. The purpose of that order was to allow the father to confirm that the daughter is in a car that honestly is fully insured. Accidents happen. If she's in a car that's uninsured, that's in an accident with an uninsured car. She could have damages that will never be compensated. I think it's a fair request to make sure that she is transported in a vehicle with full insurance. So the answer to that at this point is inadequate. The second is that the social media, TikTok did not remove this particular video. That also was required by the court. Ms. Shoemate indicates that she isn't sure how to do that. For now, I'm going to accept that. I'm going to put this over 1 month on that issue only. If that video is not taken down within a month, then I'm going to require that the daughter not have a TikTok account. She'll have to close her account. So if she wants to keep her TikTok account open, the mother and the daughter are going to have to figure out how to remove that video. Third, there was an order that any new romantic interests would have to last for 6 months before the daughter would be introduced to them. There really was no response to that by Ms. Shoemate, and it leads me to believe that that provision is also violated. Let me just say, Mr. Weiss indicated a number of concerns about this person. I don't believe I can address those right now. However, you may consider bringing a motion for a protection order in a protection order docket if you feel that he provides it or creates a danger for the daughter. Based on 1 and 3 that I've mentioned, I do find that Ms. Shoemate is in contempt. I am required to assess a $100 contempt penalty, and that's what I'm going to assess. I'm going to require that she abide by those requirements going forward. And again, we'll come back and review the social media issue in a month. So today's the 1st. We'll come back here on April 5th.
Your Honor,
At 9 o'clock. Just a moment. Who spoke?
that was me, Your Honor, the GAL. Is Vincent,
Yes.
he has a number of charges in Skamania County from November of 2022, stalking, telephone harassment, cyber harassment, harassment, threatened to kill, bodily harm. I'm looking at Odyssey right now. This is extremely concerning. I'm not sure what the court can do, except that I would like to have a little bit more time to research this to see where the cases are. But if this is indeed the boyfriend that the mother has, there should be absolutely no contact between the child and the mother, or the child and the boyfriend.
All right, well, let's set a review then for next week on March 8th. I'm also going to leave the April 5th date to review that issue.
Okay.
Let me ask, Mr. Weiss has also filed a number of proposed orders dealing with a temporary family law order, a parenting plan, and child support orders. Ms. Shoemate, have you had a chance to review those?
I've gotten through some of it, yes.
Are you going to object to any part of those orders?
Yes, I didn't know if I was supposed to file anything.
Okay. So since we're coming back next week, and since the information Ms. Fellows may find out may affect how I address the proposed parenting plan, if you want to file a response to those proposed orders, please do that by Friday of this week. And then we'll address all of those orders next week. In the meantime, between now and next Wednesday, I'm ordering that there be no contact with Vince.
Okay.
Okay.
Your Honor. Am I able to see her?
As long as Miller is not around, if this is your weekend, you can have your weekend.
Okay.
Okay. If I hear that Mr. around, that is going to have a significant impact going forward. So I just want to caution you about that.
Okay.
Okay. All right, so let's all be back here then on March 8th, and we'll take up the other orders and the additional information that Ms. Fellows has just discussed. Okay, Mr. Weiss, go ahead.
So for next week, we'll be able to address the child support motion and the parenting plan motion.
Yes, I want to give Ms. Shoemate an opportunity to file a response if she wants to.
Okay, and I don't recall, did you mention a time for next Wednesday?
It's 9 o'clock, just like today.
Got ya.
And it'll be on Zoom. Is Sean Grandin here?
Thank you.
I didn't see
Okay,
his name
thank
on the
you.
thing, though.
All right, I don't believe he was served with your show cause order. I don't have a proof of service in the file. And
Okay.
do you have a proof of service?
No, I turned one in. They know that he was served. I know that after I was supposed to come to this court date, I had to like reserve him again with all the paperwork or something like that.
When did you turn that in?
Like 2 weeks ago.
Okay. Just a moment here. Right, there was an order to show cause signed on February 14th.
Yeah, Valentine's Day. Yeah.
I don't see any record that Mr. Grandin was served with that.
Okay, well, I know he was. I have the proof of. So I just need to turn in the proof of service form, is what you're saying, and then that shows that he was served, because he was served.
All right, well, I don't see it and I can't go forward with that. What I think I need you to do is submit another order to show cause that will be at a later date. That needs to be served on him, and a proof of service of that needs to be filed with the court so I can confirm that it's been served.
Okay, I see what you're saying. Okay. Okay.
So just, you've already done an order to show cause. You can submit another one based on what's in the file. The court should sign it, and then make sure you serve it and file the proof of service with the court. Okay.
Okay. So pretty much refill out a whole another motion for the contempt of court.
I think the supporting information is already in the file with your declaration. So
Okay.
all you would need to do is, I would probably call it an amended order to show cause and set it a couple weeks from now.
Okay. Okay. Thank you, sir.
Okay, thank you. Brittany Chapman and Bryce Chapman.
I'm here.
Is Bryce Chapman here? All right.
Honor.
Oh, Bryce Chapman?
Yep, I'm here.
Good, I'm glad you're here. So there have been some promises that you were going to make some payments, and I've signed several contempt orders because the spousal support payments have not been made, along with other payments. I know you and I were here around December, and you had promised you would pay $500. All of that resulted in a couple of weeks ago, I ordered that you spend 5 days in jail. And I'm glad you're here today. I need to hear what your plan is to make these payments.
Your Honor, I'm sorry I neglected the court and the orders. I'm asking if I can have more time to review with my lawyer, so I can put in with my response. I plan on making payments and doing stuff. Half my checks are getting garnished with child support, so my wages are cut in half from my old job to what they are now is half of what I used to make. That was sent through with Cowlitz Sport Services. They are aware, and they're taking out of my company I'm working for now. So I'm trying the best I can, but there's no other good reason. That's how it is right now. I will plan on trying to come up with some kind of payment plan that I can do, but as of right now, I'm sorry that I neglected the orders and did all that.
Do you have an appointment with an attorney that's scheduled?
I talked to her last night, and I'm going to talk to her again after I get done here, and we are going to sit down and meet and then have write up a response.
All right, thank you. Ms. Chapman?
The way that I see it is these orders were made February of last year, when he was making very good money, and he still was not making any of those payments the entire time. So I don't see any of those things as valid excuses or reasons. And as far as a lawyer goes, I do not believe that at all. And if you have money for a lawyer, how come you don't have money for even paying for a sport for your kid, or money to make these payments at that? And also the 5 days were not spent in jail. He didn't even do that. And again, the lawyer thing, I just don't believe it. And during all the child custody battles that we just went through with you already, he is very good at trying to get out of consequences, and you're going to wait till the night before court to do so. Story that I just don't find it believable, and missing all of the court dates that he has missed. But now that it's down to he has to go to court, he wants to show up, and I'm fed up with all of it at this point. And there is a lot of sports to be paid, but you can pay for a lawyer, which is, again, I don't believe. I think that's it.
All right, thank you. We have been here quite a few times without any effort really to make the required payments. And that's certainly frustrating to Ms. Chapman and noted by the court. When somebody comes in and says they want to meet with an attorney, there's really no way to assess whether that's valid or not. But I very typically will give somebody time to do that. And sometimes the attorney can be helpful in getting these issues resolved. So I'm going to put this over 2 weeks, Mr. Chapman, to allow you to meet with your attorney. So that's to March 15th at 9 o'clock. I'm not removing the requirement to spend 5 days in jail at this time. That may come up later. But I am interested, if you meet with your attorney and if you put together a payment plan, I'd like to see that on the 15th. In fact, if you don't have a payment plan on the 15th, I'm going to be a bit concerned. Okay. So let's take a look at that. My interest here is not to put you in jail, is not to do anything other than get Ms. Chapman paid. And I will use whatever tools I need to get that done. But at this point, I'll give you 2 weeks in order to meet with your lawyer. Okay.
Thank you, Your Honor.
All right. So we'll be back here March 15th. Ms. Chapman, yes.
Haven't we had a whole year of chances? I don't want him to go to jail either, but it seems every time he does show up to court, which is few and far between, he just gets another slap on the wrist. And he was ordered 5 days in jail before the first, or there would be a bench warrant, and he did not do so. And then he shows up today magically. And then now it's just another slap on the wrist, and he's not getting it. And I'm just frustrated with the mental and emotional abuse that goes on regarding this. and I don't know. It's never gonna end ever. And I just spent $250 to put them in sports, and I don't work. And he made $37.50 for the entire year that this has been ordered. And now the excuse of, well, my job doesn't pay as much, the job that he just started working. So I don't, is there a bench warrant as of today, like there was supposed to be, or no?
We were going to consider a bench warrant today. I'm not going to issue that. And let me just say, I understand your frustration. But again, my usual practice, and I'm not going to deviate from it now, is when somebody comes to court and says, I need more time to see a lawyer, I typically give them that time. I know there's been a lot of non-compliance in this case. Ultimately, we'll address that. But I'm going to give Mr. Chapman time to meet with his lawyer.
Okay, I just hope that the money he should be paying me isn't what's going towards this lawyer from the money he claims to not have. So that would be unfortunate.
And that will be a factor I'll consider.
Okay.
All right. Thank you. We'll see you both back here on March 15th.
Okay, thank you.
Either.
All right, thank you, Your Honor.
I've got a phone in the waiting room. Let's see if that might be.
I'm here, Your Honor.
Is Ms. Chavez here?
Yes, I'm here.
Okay. All right. All right. Are we ready to go forward on that particular issue, which is whether there's contact between the child and the boyfriend?
I believe so.
Okay. Let's hear from Mr. Chavez first.
Yes, Your Honor, I will. There's actually a lot of stuff that I'm actually still concerned about with the matter of that David guy being around my son.
Okay. This is the time to talk about it.
Okay, I know his name's on the lease. And I do strongly believe that, you know, he's been over at Miss Chavez's house while my son's there. Because when my son gets ready to get picked up on Sunday, he's always telling me and my parents that he's scared to go home. And when I asked him, I know I'm not supposed to, but I was curious, but I asked him if David was there. He said that he has secrets. And I was like, okay. And then, you know, he happened to tell my parents that David's there all the time. You know, and I just don't know what to do, because if he's there all the time, you know, and like my son always coming over here all happy, you know, does not having accidents, you know, we're having a good time, this and that, but I'm just confused on why when he comes back to his mom's, you know, I'm finding out that he's having accidents, he's doing this and that, but he's never had problems over here during my visits. I just want to make sure that my son is safe and that all the visitations has been going good for my son and I.
All right. Thank you. Ms. Chavez, any response?
He is not, since you put it in writing saying he cannot be around, he has not came down. My son has not seen him. I might have been on the phone with him, but me and him do not have a relationship anymore, because my son is more important than that. Question on that one.
Go ahead.
Mr. Sergey actually lives at my residence. He's on my lease. So technically you are kicking him out of his apartment. And if you guys want documents of that, I will go to my landlord and get a document, because he signed papers. I make sure my kids get everything. Mr. Chavez does not give me a penny. I work my ass off every day from 9:30 to 5 to support both my kids. I don't know why my kid does it sometimes. His accidents, we haven't, because he stopped, and once in a while he'll have it, but coming back. So I don't know what Dad has said, but we've noticed. I've asked my son. Only thing I have asked my son when he comes home is, "What did he do with his dad?" And he'll say nothing because that's his normal response. And then I'll ask him, "Did he eat? What did he eat?" Because our son is very picky, and that's it. Because I don't want to question him because I know it's not right, and I don't want him upset.
Your Honor, can I say something?
All right, I'll let you, and then I'm gonna go to Ms. Day.
Okay, Ms. Chavez knows that my parents, since day one, Austin's been born, and even while she was living over here with the kids, this and that, and with my visit, Austin has always been fed and, all the time here. And then she's telling my dad, she's saying she's working 9 to 5, but she's telling my dad, she's been working or living off of 20 hours a week, that she's fine with that. Last court date, she said in open court saying she didn't want nothing from me at all.
All right, let me go to Ms. Day. Okay, Ms. Day, any comments?
So really the only comments I have, Your Honor, kind of go back to the first hearing we had February 1st. And the hearing before that, where you had ordered no contact with Mr. Sergey. Mother indicated last month that he had moved in with her and was on her lease and was having contact. And I have no reason to think that that has not happened or that anything has changed. Nobody has submitted any documents that he is no longer living there or not on the lease. You had ordered mom to file any well, both parents actually, not just mom, to file any declarations, which is why I think father filed for the contempt, and mother hasn't submitted anything in writing or provided any information. The only contact I've had from mother was last night at 5:30 when she contacted me and wanted to talk to me. I was not able to oblige her. I called her back, but she didn't answer, so I left a message. My concern is this matter is kind of languishing, is going on and on. I think we just need to set it for trial. If Mr. Sergeyev is not living with mother and not on the lease, then she needs to provide proof of that. Otherwise, it's my belief that he is still there and having contact. There's no reason to think different based on her own testimony.
Your Honor, the only reason he got on the lease is because the manager wanted him on the lease because somebody smashed his front window. And this was before we went to court. So that's why. So I did talk to her, and then I went to the office asking, can we see video? And she's like, we need to put him on the lease to protect. And I'm like, okay. So, I mean, I have not gone there because the office opens at 8:30. I take my son to school, and then I have to drive to my clients. If you guys want proof of my hours of work, I can do that because I work Monday through Friday. And I got off at 5:30. So that's when I called you because I always work. I have only weekends. And I don't know with my son, I don't know if my son understands or not. He's only 6 years old. I mean, there has been things going on in school that we're trying to figure out. And I don't think Mr. Chavez knows because he can ask his dad anytime because we are not supposed to have contact of talking from what you said. So I let his stepdad know what's going on in school with the boy. And from what I know, not sure if it's true or not, he has not asked about him, about school or anything. I don't think it's right that he can call the school because he can ask his dad.
Your Honor, I ask my son every Wednesday and every Friday how his school goes.
I'm ready to make a decision here. Okay. So we're not going to go back and forth. The motion here was one of contempt. There was an order that Austin not see Mr. Sergey. Mr. Chavez is concerned that there is contact with Mr. Sergey after that order. And part of the evidence of that was the fact that Mr. Sergey was on the lease with Ms. Chavez. Ms. Chavez is indicating, well, that's for reasons other than Mr. Sergey living at the premises, and is adamant that Mr. Sergey has had no contact with Austin. But all right, well, Mr. Sergey cannot have any contact.
I would like to understand why, because if you guys looked in Mr. Chavez's past, in his juvenile, he did something, but I don't know the whole situation, what happened. And then he has the assault on his record. And then he has the open CPS case, which no one's doing anything about.
Your Honor, that has no relevance with this.
Just a minute, Mr. Chavez. My understanding is there's a felony conviction against Mr. Sergey as an adult.
That happened years ago.
And it's concerning enough that the recommendation is he not have any contact with the child.
But I have more concern of his dad. I mean, he my oldest, and we're still trying to get it prosecuted. No one has talked to him, which is a joke.
So, Your Honor, I have been very thorough in my investigation regarding
Let me hear from Ms. Day here for a moment. Okay, go ahead.
I've been very thorough in my investigation of those allegations, including the law enforcement records, the records from DCYF, et cetera. There is no open case involving father. There is no open investigation regarding those allegations involving her daughter. That is a closed deal at this point until there's more information. Law enforcement is not pursuing that. They may in the future. I can't speak to what could.
How is he not protected when my son was always with me, and when Mr. Sergey was with me, he was never alone with my kids? I don't understand it. Especially when it happened 14 years ago, almost 15.
So we're just here for that moving forward, Your Honor. Do you want me to do more investigation? Is there something else you would like for me to do?
I just don't think it's fair because both kids keep asking about the person, and they were happy. I mean, he helped me take care of my kids because my just not gave me a dime for my son. I don't want shit from him because I've done it all. I've worked my ass off to take care of my kids.
Pointed out, we don't have any declarations to that effect, or we don't have an effort to get Mr. Sergey off the lease. What it creates is what we call a factual issue as to whether there's actually been contact or not. If there is contact, then the court may have to make a modification to the parenting plan. And that factual determination is typically not done on this docket. It's done at a factual trial in front of one of the judges. And I think Ms. Day's suggestion that this should go to a trial on this issue is one that I think is well taken, because both sides will need to testify and state their claims. So what I'm going to do, I'm not going to make any changes in the parenting plan at this point. The order that Austin not see Mr. Sergey remains in effect. I'm going to put this on what's called the Universal Trial Setting Calendar for March 15th. The court will give you a date for that hearing. And then that's something that a judge is going to have to hear from both sides and make a factual determination about.
So would
Is
this
that
be a
gonna
hearing
be on
to
Zoom?
establish the final parenting plan or just on the contempt?
Just on the contempt.
Okay.
So the
Thank
trial's
you.
on the 15th, is that what you're saying?
Trial's not on the 15th. That's a date when the court will give you a week that the trial could occur on. And then closer to that week, they'll give you the actual trial date.
How would we know?
How would we know? There's a subsequent hearing. It's called a readiness hearing a week.
So we all need to be present at the March 15th at 1 o'clock to get a hearing date
you.
set.
Your Honor, I have a question.
All right, one more question and then we'll go.
If I got me a copy of my lease saying he's not on my lease anymore, would that work?
Well, that would be evidence that I would present at the trial.
Okay, do I need to do it to that judge or you or?
I would file it with the in the court file so that it's available for everybody to see.
Okay, and do I have to serve both of these to Mr. Chavez and?
Ms. Day, you should provide a copy of that to both, yes.
Okay,
All right. So to Vaughn and Kiyoshi, we put this over a week because I think Ms. Fellows wanted to have additional contact with the parties. Were you able to do that? Ms. Fellows?
Yes, Your Honor. I did want to review the declaration that the father had filed. He filed it on January 31st, but he did not serve it until the day before last week's court. So I wanted to be able to review that. It's interesting that the copy that was served to me was not signed, was not a signed copy by the father, although the one that was in Odyssey is signed. And then the other thing is that there's actually some pictures that are in the copy that was served to me, but they're different than the ones that were on filed with Odyssey. Not an overly big deal, but just wanted to bring that to the court's attention. I do have some concerns about the father's declaration, is that he's pointing a lot of fingers at the mother, that we're taking a lot of the information from the mother. He had issues with me as well. But the simple fact, and he basically said that he was not going to do what he had been ordered to do. So that was, I have concerns about that. But what I will say at this point, I do have some new information. I did call his treatment provider. I did call them last week, and then I called them again yesterday. He is now basically in compliance. He had not been in compliance throughout this whole time doing his AANA meetings. He was supposed to do 2 times a week since November, since he started. He had not done any until about February 10th, I think, was the first one that he submitted. So from last week to this week, he actually has done them all. I talked to Jamie, his provider. He basically was going to like 2 or 3 meetings a day to get caught up. She did tell me he is caught up. I did ask her how much longer he had to go. And she counted and basically said, to her surprise, is that he is basically done with phase 1. He had 12 weeks to do the group sessions. He has done those, although he hasn't necessarily been overly consistent, but he has completed those. He did the AANA, he's completed those. So she has now basically graduated him to phase 2, where he only has to do 1 monthly meeting for about 3 months, is what she said. So that's good. I commend the father. I know it's been a struggle. So I commend him for that. The other issue at hand that he basically said that he was not going to do in his declaration. But he has since called for a DV evaluation. I emailed him about that, and he said that he had called, I think it was February 10th, and he got a date for the evaluation for March 15th. I did call them yesterday late afternoon to just confirm it. I have not heard back. So that is another good thing, that Dad is finally following through with what the court had ordered. But his declaration is concerning, just mainly because I feel like he's blaming the mother for the information, for having to do these services, when in reality, he was discharged from the military because of DV and alcohol. So there is that factual information that I'm largely basing my information on and what I was concerned about. That said, my understanding is that the FaceTime visits have gone much better since the court ordered that they were to be at 6 p.m. on Wednesdays. That has made it where it is, everybody knows what time and everything else, so it can be scheduled. So that is going really well. The mother has indicated that the FaceTime visits have gone longer since they have been so consistent. So that is a really good thing. So at this point, given the information that I had gotten last night or late yesterday afternoon regarding treatment, I am recommending that the in-person visits restart again. I am a wee bit concerned about Dad not being overly consistent with his DV if he is recommended for treatment. But then again, he did do what was asked of him to get his in-person visit. So I think that we need to move forward with that.
And that would be supervised with Ms. Brandhorst?
She supervised, yes, at this point. Apparently she is not able to do it given the change in Dad's work schedule. So Parents Place was able to do it. I believe it was on Tuesdays because Mom works on Wednesdays. So Tuesdays was workable for Parents Place back about a month or so ago. I hope that they would still have that availability. And that's here in Longview.
Let me hear from Ms. Vaughn first, and then Mr. Kiyoshi, I'll hear from you. Ms. Vaughn, anything you want to add at this point?
Yes, so I am okay with the supervised visits happening since he is in compliance, but I do also share the same concern with Beth of the consistency. Like she said, he hasn't been in compliance since this last week with treatment, and he happened to make up the last 4 months of his outlined plan in this last week. So I'm concerned that with the treatment moving from weekly to monthly, it may cause him to be able to slip through the cracks again like he did when he was getting supervised visits back in November. Is there a way to make sure like we are able to get, like can he turn his AA slips into Miss Fellows or something so that I can check in with her since I can't contact his treatment center to be able to make sure he's in compliance? Or could there be a way for him to like email me his slips so I can just see that he's still in compliance before a supervised visit is made?
I think I prefer that Ms. Fellows get that information and that she report to me on our review sessions. I think that makes sense. And if Ms. Fellows feels there's a significant concern, she can put the case on the docket if we don't otherwise have it scheduled.
Okay, and then
Get in touch with her about that, but I think I'd rather that information go to her.
that's fine with me. I just wanted to make sure there was some way someone knew if he wasn't in compliance again. My other concern is actually pertaining to the restraining order that I had proposed to you at the whole beginning of this. So since then, there's been an issue with how he has served me documents, both in our summons and petition for our divorce and the motion for temporary family orders. It states that they are to be served to my sister's address across town. My address has been listed as confidential on everything. Due to the nature of the case, I didn't want him or his family to know where me and my son were living. And somehow he stalked my address to the point of finding us, locating us, and having us served at my home twice now. One being last Tuesday when we got this set of his declaration. The first time it happened was back in October, and he was out in his car outside my home, despite the bench order of there supposed to be no contact between us. It's very concerning, and it's kind of ruins the peace of mind and well-being and safety in my mind of my own home. And I ask that that be granted. I had gone to law enforcement with it after I was served last week, and they had said without an actual restraining order signed and in place, they cannot act upon it. So I'm concerned about this, for sure, concerned about this. I want to be able to feel like I'm safe in my home.
Okay, thank you. Yeah, any response to all of this?
Yes, Your Honor, can you hear me?
Yes, I can. Thank you.
Okay. So again, I wrote down my thoughts just because I have a lot to say, but so I did get the evaluation scheduled for March 15th. As far as being consistent with my treatment and everything in my declaration, the reason why I had questions about, or not questions, the reason why I had problems with doing these treatments is because we were told it all started with the FaceTime visits. We had to create a space where me and him can interact. That wasn't happening. If it's not reciprocated on her end and I'm doing all the work to see our son, where's the equality in that? That's the whole thing with the consistency. But after last hearing, I did start going to the AA meetings, and I've completed them. I've talked to my counselor. I'm good with that treatment, and I'm on the phase 2. So my concern now is that the visitations with our son, the FaceTime visitations, they're going a lot better now. You put it off a week, last hearing, which was last week, you put it off a week. I'm moving forward, and I'm taking these steps so I can have quality time with my son. These virtual visitations, 30 minutes, they're good, it's something, but I need more than that as a father. I can't raise him over a camera. And with the protection order, if she feels she's unsafe, I went every time I go down to turn in paperwork, declarations, or anything like that, I go to the court and I've asked them, because they've sent me down to the sheriff's office to try and get these declarations served to her. The lady at the counter told me I just need a third party to get the papers to her. Since the protection order was put up, not once have I tried to go see my son. Not once have I gone to her house to cause problems. The reason why I have someone serve the papers to her home, which I wasn't stalking her to try and get it. I'm just trying to make sure she gets the paperwork. I don't want any gray areas where I send it to her sister's house and then she says she never got it. I want to make sure she actually gets the paperwork.
Well, if she wants to be served at her sister's house, I think that's something that we need to comply with. And if you want to send it certified, to make sure you get a card back so that somebody can't come back and say, well, it never was received. You're free to do that, but I don't think it's appropriate to ignore that request and simply go to her house.
Your Honor,
Understood, Your Honor.
let Mr. Kiyoshi finish. Go ahead.
So, okay, that's understood. It won't happen again. I don't go near her or her house if I don't need to. And I don't try to cause problems when I do. I just want to make sure the paperwork gets to her. That's all. And it's not me serving. So I thought it was okay, but now I understand, Your Honor. So from what I said earlier, not once have I, other than to serve paperwork, not once have I tried to go see my son. It's been 2 months since I've seen him. I still have his Christmas present sitting here. I've done the visit. I'm in compliance now. And then, sorry, I wrote my thoughts out because I have a lot to say. So Miss Beth Fellows is saying I can have those supervised visitations. Other than not being in compliance and her not keeping up her end on creating that space for me and him to interact, and I've mentioned this in court multiple times, it's hard to interact with him, and like, I can't raise a kid over a camera. No one can. So the supervised visitations are back on the table from what Ms. Beth Fellows said. I would like quality time with my son unsupervised. And if that means that we have a third party pick him up, drop him off, and me and mom don't ever have to talk to each other, I'm okay with that. But I can't raise a son over a camera. The FaceTimes have been going good, but mom is in the video too, and that's okay. I'm okay with that. So I'm watching them play. That's fine. I can't play with him over a camera. So I'm not mad that, you know, they're sitting there playing and stuff. It's his mom. But what am I doing? I'm sitting there just watching. And like I said, the supervised visitations, it's an hour, it's 2 hours every other week. That's 4 hours in 30 days. How is that? It's not helping build the relationship I already have with our son. I need some quality time with him, with her, and I mean, because she doesn't feel safe. I'm okay with that. We don't ever have to see each other, but we can have a third party pick up and drop off. That's fine. If it's a day off and I need to spend the whole day in Kelso because she doesn't want me too far, that's fine. I'll find something to do with him in Kelso for the whole day. They're garnishing my paycheck, which I have no problems with supporting my child. I have him under my medical insurance. Like, I have no problem with, but he's under my medical insurance. Like, they're garnishing my paycheck for him. I have no problems with that, but I have no quality time with my son. So she's okay with me taking care of him, but not having that quality time with my son as a father. Like I said, his Christmas presents are still here. I haven't seen him in 2 months. I'm in compliance now, but I want quality time with our son. Just me and him, without her, without anybody. I can't raise a son. I can't raise a son 4 hours out of 4 hours in a month. It's not healthy. He's always going to be questioning, where's my, he's used to it now, but because that's what was put in place. But I need to be able to, hold my son, hug. I haven't hugged my son, but I'm doing my best to take care of him. She's okay with it if I'm taking care of him, but I'm not there to raise him. That's not okay. I'm a father. It's my right to be able to raise my son. And I'm sorry if I'm getting loud, but I'm just, this has been going on since September. October. Like I need time with my son. I'm okay with taking care of him, but I'm taking care of him and he lives down the road and I can't even go see him, pick him up, take him to the park. I can't do any of that. And it's frustrating.
Mr. Kiyoshi, I fully support your desire to have quality time with your son. We're here because there was an alcohol issue that resulted in a termination from the military. There was treatment ordered that initially you didn't comply with. And I had ordered for over a month now a domestic violence evaluation. And now you've set that up for the 13th. You're doing, at this point, what the court needs you to do to make sure that when you're with your son, that your son's going to be safe. Okay.
Right.
But we are not at the point of unsupervised visits. And I will just tell you from my perspective, I want to see the results of the domestic violence evaluation before I would even consider that. And
yeah,
if there's treatment that's ordered, then we'll have to look at that. Again, you're moving in the right direction, but I will just be totally transparent with you. This is going to move a lot slower than you want. And you may get frustrated. And I guess if you want to, you can tell me about that frustration. But I just want you to understand that's how this process is going to work. But I want it to move forward. So it sounds like when we set a specific date for the video visits or in specific time, that those started going better. That's good. Ms. Fellows is now saying, let's go back to the supervised visits because you're now in compliance with the treatment. You've scheduled the DV evaluation. That's good. We're moving in the right direction. Okay. If the domestic violence evaluation, let's say is okay. I don't know what it will be. Then maybe we take another step at that point. So I am going to tell you, you're going to be frustrated with this process, but I'm going to take the steps that I need to make sure your son is safe. Okay. Now, Ms. Fellows wants to say something, and I'll let her do that.
I was thinking, instead of the every other week for supervised visitation because he has done what this part of it is to do every week, 2 hours at parents' place.
I would be willing to once we have the DV eval in hand to see what it states. So potentially at our next hearing, if that's okay. This one I would still be willing to do every other week since he is just transitioning to once a month with his AA stuff. I kind of want to see if he stays in compliance with that, given the history of not being in compliance.
I don't see much danger to your son by having supervised visits before that DV evaluation. So
that's fine. Can you also just clarify, he had said that he's been serving them to my house and he wants to make sure that service is made. He has not filed any proofs of service. So he could also do that to make sure, to show that he's done it.
Okay.
And Your Honor, I did hear back from Kathy Griffin at Parents' Place. They do have between 10:30 and 1:30. So there could be a visit like 10:30 to 12:30.
All right, thank you. I appreciate everybody's input. I am going to order supervised visits at Parents' Place. That will be every week going forward. The Wednesday video visits, I think they were 6 p.m. Will continue. Mr. Kiyoshi is ordered to not go to Ms. Vaughn's house, not have anybody on his behalf go to her house. Service will be at Ms. Vaughn's sister's house. Either that can be done personally on the sister or sent by the mail. Mr. Kiyoshi, I don't want you to personally serve anything on the sister, but if you want a third party to serve her on behalf of Ms. Vaughn, you can do that. But primarily, I think you should be able to just send stuff in the mail if you're doing declarations or whatever you file.
I had a question, Your Honor.
Just a minute, I want to pick a review date. Do you think Ms. Fellows will have evaluation done? If he has the evaluation the 15th, would that be completed by the 29th, or do you think we need more time for that?
I would say, just to err on the side of caution, maybe another week or two after that, just in case.
Let's go April 12th. So the DV evaluation should end up with Ms. Fellows. So if you need to do a release of information with them so she can get it, I expect her to review it and she can report to the court about it when we get back together. All right, Ms. Vaughn, go ahead.
We have a family vacation plan that is out of state for about a week in the end of March. Is that going to be okay since he will now have to miss a visit?
I'm willing to accommodate. So that means the Tuesday, the 21st and Wednesday, the 22nd.
You can make the call Wednesday, totally fine. I just won't be able to take you in.
All right, so we'll have to skip the 21st for the in-person visit.
Yes, Your Honor. I had a question, just to clarify something. So so I'm now on. I can see him weekly.
You can do what?
I can. The in-person visitations are weekly.
Are weekly, yes.
And they start. So you said it starts on Tuesday. Can I set one for this Tuesday coming up?
I think you may have to call Parents' Place, but the first one should be on March 7th. And then the 14th, and we'll have to skip the 21st, and then 28th and 4th and 11th before we get back together.
And just to let you know, is that Kathy at Parents' Place said that she needs to have paperwork from both parents before the visits can be started. So it's up to both parents to get it ASAP.
Okay.
If you for the visits to start next week.
So everybody needs to cooperate. I think we added some time on the weekends.
And it appears like it's going well. I'm a little bit concerned about Dad. I've been trying to get a hold of him. I tried to do a drop-in visit. He must have given me the wrong apartment number or something because I couldn't find the apartment. So I'm a little bit concerned about that and that he's not here. Regarding Mom, Haley, I am thrilled to tell the court is that I did talk to her therapist, her counselor, and she is doing extremely well. She has been accessing her counselor as needed, especially since considering is that Andreas was taken out of her care basically because of the CPS investigation. She was limited contact. And then her older son, September, who I am also the GAL for, was basically, Dad took him and the court basically ordered that September be with Dad, who is in Montana. So this happened, I believe, in September of last year. And so talking to the counselor, I mean, mom was extremely angry, and understandably so, but that she worked through it. She has accessed the services, the supports, and everything else is needed. She's been taking her medication. She does have the bipolar diagnosis, PTSD, severe anxiety, and some depression. But she has been stable from what April Gressett said, her counselor. The one thing that I did ask for is an updated safety plan, because a lot of times with people who have bipolar, specifically, is that they have a safety plan in place in case they have those manic highs or manic lows. So I did talk to April about updating that, since there's been so many, really good changes with Haley. And she said, yep, she would get on it and that she would get me a copy. The other thing that she was thrilled to report is that Haley had major issues with impulsivity. She would just like jump in or do something and then realize later that, oops, she probably shouldn't have done that or said that or whatever. And she's really worked on that. And that has been something that she doesn't really have as many issues with now. So again, that's a really good thing. So at this point, because I haven't been able to make contact with dad and stuff like that, I would ask that we do status quo. But I do want to move forward with this. I know mom is extremely frustrated that we haven't. But I need to connect with dad before I can make any recommendations to move forward. I know mom at least ways some time ago, and I think that she's still agreeable to, basically like doing a 50-50 plan. But what that exactly looks like, I'm not exactly sure. But I wanted to let the court know that that's kind of where I'm going. Also that the mental health issues that have been a significant issue and concern regarding mom, she's doing well.
Thank you. Anything you'd like to add?
I am in complete agreement with eventually going to 50-50. I know we can't do much today with Tegan not showing up again. That is a concern of mine, that he seems to do things which is convenient on his time and what he would like. So that's a bit frustrating. But I understand if the court can't move forward today because of that. But I am in complete agreement with a 50-50 schedule. Obviously, the court will have to decide what that schedule looks like. The only thing that I am kind of requesting today is that my partner of almost 2 years can get from no contact to supervised contact while the guardian ad litem does her investigation on him. Because as far as I know, that has not started yet.
And what I would like to respond to that is, I understand that she wants her significant other to be able to have contact. I did want to talk to his former wife, the mom of his daughter, I believe. And so I wanted to reach out to the mom and to Haley to get some more contact information so I can do that. There had been some concerns between Haley's boyfriend and his former wife, where there was a protection order and there was just some things like that. But it sounds like, from what I'm understanding now, is that they are working together and those issues have been resolved and they move forward. And so if I can ascertain that that is indeed true, then I would be fine with Nate being able to have contact as long as Haley was there with Andreas.
All right, I'm not going to change that situation right now. I'm going to set this for another review on March 15th. That'll give Ms. Fellows time to contact Mr. Kissinger. I'm surprised he's not here too. I've seen him on a couple dockets and he's usually involved. But I will say this, if he chooses not to be with us on March 15th, I am going to consider a 50-50 schedule at that time. So Ms. Fellows, you may want to be thinking about what that would look like. And you may even want to discuss that with Mr. Kissinger if you talk to him.
Okay.
Okay. I'm very pleased with how this has progressed for Ms. King, and I think we are at a point where we need to go to a more permanent and a 50-50 schedule between the parents. So, okay. All right, so we'll see everybody back here then on March 15th. I'll also address the contact with a significant other on that date. Okay, just give me
Thank you, Your Honor.
Thank you, Ms. King.
Your Honor, Casey Lynn, on behalf of the state, we just put in a notice of appearance.
Okay. So we're here for temporary orders, a parenting plan, and child support, although since the state's involved, I'm probably not going to order child support at this point. I'm going to let the state get involved.
That would be our request. Thank you, Your Honor.
These orders have been proposed by Jessica Palmer. Mr. Palmer, have you had a chance to review them?
I have.
Do you have an objection? And if you do, what can you tell me your objection?
Yes, Your Honor. My objection at the moment is for Jessica to actually have custody of the kids. I am not comfortable with that for a couple reasons. One, my children do not feel safe with her, and there are CPS reports stating that. Unfortunately, I was not able to get those reports in time. It takes 90 to 120 days to receive those. So I am still waiting, but I have a email correspondence from DCYF stating that they are looking for those records for me. And those records are stating that my kids do not feel safe living with their mother.
And you said you have custody. Is there an order to that effect at this point, or something from DCYF that indicates that?
I think so. I'm terribly sorry. I'm not really 100% sure on that paperwork stuff. But I am receiving child support and also food stamps at the moment for my children.
Ms. Palmer, what's your response to that?
Your Honor, it
Yes.
has been almost 18 months since I left my husband. I lived in a domestic violence shelter due to the domestic violence that he put me through. I had a restraining order against him, which he violated numerous times, contacting me on Facebook Messenger, despite a judge telling him he could not contact me. I have all of my original messages and screenshots of him stating to me that he would not go through a third party, and I did not get to see or talk to my children until I dropped my restraining order. Year to date, I have given him $6,410 in child support, but I am being told by my coworker that lives in the same complex that for the third time in 18 months, my daughter does not have a decent pair of shoes, that she has holes in the bottom of her soles. And when my coworker asked her why she doesn't have a new pair of shoes, my daughter told her, "My dad's broke right now." When I had my kids for Christmas, which was the first time I had seen them since last August because he will not let me see them, my daughter told me that she didn't have any underwear that fit her, and that Jason had to cut the sides up of all of the underwear that she had, and that they pinched her. So despite the fact that he gets $641 a month from me in child support, I'm the parent that had to go to Walmart and buy her underwear to make sure that they fit her correctly. I still have the pair of shoes that he sent her to my house with in August, where the sole is almost completely falling apart. A few days prior to me having my kids, he posted on Facebook of the engine that he's building. He posted a picture of the engine he's building from the ground up, and he intends to spend several $1,000s on a high performance engine, but he couldn't spend $10 on a pair of shoes for my daughter. And since child support has gone into effect, I work 2 full-time jobs. I work 7 days a week. Most of my shifts are 10 hours long, and I do that to ensure that he gets the child support and that my rent is paid, as well as my car insurance. I get 1 day off a month, and I haven't been allowed to see my children on the 1 day off that I have a month. I have had my kids stay at my house overnight a total of 2 times because he wouldn't let me. No, excuse me, 3 times, February, August, and December. I have had 7 visits with my children in a year and a half because he will not let me see them. I had tried to stay in contact with my son through text messages. And the last message that I got from my son said, "Mom, I love you. I don't want to live with you. I only want to visit you." This was a few days after I served my husband orders to be in court today on the restraining order. My children called me before I got this message from them, and they wanted to know why I served a restraining order against their dad again, why I keep hurting them. And my daughter's exact words were, "Now you can't see us for a really long time." I did not serve him with a restraining order this time, and I assured my children that I did not serve him with a restraining order and that I am doing everything in my power to see them more. But he has repeatedly told my children that I do not care about them anymore. I would also like to bring up the living conditions. My husband lives in a 23-foot motorhome, and there is absolutely no privacy. The kids basically have a bunk bed to themselves. At my house, I have a 2-bedroom apartment where I gave them each their own bedrooms. They have full-size beds, they have bedding, they have access to a shower. When I saw my children in February of last year, both Christmas and February, because of the condition of their hair, was absolutely atrocious. Last Christmas, a year ago, when I saw my kids, my daughter's hair was so matted, it looked like she had dreadlocks. And I had sent toiletries twice to make sure that they had shampoo and conditioner and body wash for their access. I have the receipts for that still. And when my daughter came to my house and I asked her why she wasn't using the shampoo and the conditioner, she said that because they run out of hot water too fast in the trailer, that they're not allowed to use the shampoo and the conditioner and the body wash. They're only allowed to use bar soap. My daughter's hair was so matted that before I could even wash her hair with soap, I had to put half a bottle of conditioner in her hair and let it soak in her hair for over 30 minutes before I could finger comb it out. When I finally got that out and I actually got shampoo in her hair, the water coming out of her hair was dark brown and oily. It made me gag. She had scalp chunks coming out. She had food chunks coming out. And when I finally got her out of the shower, I realized that she had lice. And I Googled the lifespan of lice, just so you know. In order for her to have all 3 stages of lice, both including the nits, the live bugs, and recently hatched eggs, she had to have had lice for over a month that my husband did not know about. I sent a message to my friend who was acting as our third party to let him know that the kids had life. And his response was to tell her that I didn't know what I was talking about. It was paint or glitter in their hair.
All right, ma'am, I'll give you about 1 more minute.
Okay. I have the receipts for the shoes that I bought my children or my daughter in April. I have receipts for the toiletries that I have sent along. I have receipts for the underwear that I provided for my daughter. I just want to have a relationship with my kids, and I don't feel like Mr. Palmer has their best interests in mind. And he's stating that they don't feel safe when they're living with me, but they've only been at my house 3 times. They never once told me that they did not feel safe with me. They've asked me repeatedly when they get to come back and when they get to see me. I hate that I have missed a 1.5 years of my kids' lives, but once again, I had a restraining order in effect and he chose to violate it numerous times. He told me he would not work with a third party. When we went before the judge for our child support hearing and the judge asked him about it, he said that no judge had assigned a third party and therefore he did not have to comply. The judge did not specifically assign a third party, but she made it very clear that he was not to contact me. He had to have third party contact at all times. And there is no custody order in place. He served temporary, or he filed in his original divorce, he filled out the first page and the last page of the custody. And the sole reason that he stated that he wants sole custody and 0 contact from me at all were that the children are afraid I'm going to take them away from him and they don't want to live with me. He did not fill out another single page in that parenting plan. That was also his reasoning for trying to get a restraining order against me, which the other judge dropped. She did, however, feel that I needed to have a no contact order against Mr. Palmer for the mental abuse that he had. She made it very clear that he was not to contact me, not in person, not on Facebook Messenger, which once again, I have screenshots of every single message that he sent me during the time of my restraining order. He used my restraining order to keep me from my children.
Okay, Ms. Palmer, I need to kind of tell us what direction we're going to go in, okay?
Your Honor, if possible, I do have some more to say about all of that.
Well, let me just tell you what I do in these situations is I appoint what's called a guardian ad litem. And in this case, I'm going to appoint a guardian ad litem at county pay. They will interview both of you. They'll look into past issues with CPS. They'll talk to the children and they'll advise me what their job is to tell me what's in the best interest of the children. And so that's what I'd like to look at. I understand you probably can address all of the issues that Ms. Palmer stated, but I think it just in terms of understanding all of this, it's going to be better if I appoint a guardian ad litem at this point. So I'm going to appoint Ann Height as the guardian ad litem. I know this will be frustrating to Ms. Palmer, but Ms. Height needs some time to get information, meet with everybody before she can report back to me. And so I'm going to need to put a review out. I think we can go to the end of March. So that would be on March 29th. I'm not going to make any changes in where things are at right now, which means there may not be any contact between the children and the mom until then. When Ms. Height contacts you, it's important that you cooperate and give her all the information that you can. And it's certainly, Ms. Palmer, everything you've told me, you need to tell to Ms. Height so she has that information. Okay.
I'd be happy to tell her everything. I'd be happy to show her every message.
Okay. I'm saying that's what she's there for, to have you communicate all of that so she can make an informed decision. Mr. Palmer, similarly, whatever information you have that's important for her, you should give to her. Okay.
Yes,
so
sir.
That's the only order I'm going to enter today. Is I'm going to appoint Ann Height, and we'll be back here then on March 29th at 9 o'clock, hopefully for a review and an update at that time. There are two matters on the docket. One is a protection order issue, which doesn't really belong here, but it's here. And then also there's a motion for temporary order. So where are the children right now?
They're with me.
Okay. And is that pursuant to a protection order that has been entered, or has that just been the case?
I did try to include them in the protection order. It looks like they weren't, and we were going to decide with this hearing where that fell.
Okay. How long has it been since Mr. Mills has seen the children or had any contact?
I got the children on February 1st. And he was supposed to get them back around the 9th or the 10th. And I found what I believe was steroids. He has a long history of steroid use and other substances, including an arrest. And I was not comfortable giving the kids over to him for the visitation that we had agreed on. He did see them on the 25th briefly at his sister's house.
25th of February?
Yes.
Tell me, Ms. Mills, what you'd like to see going forward.
I feel,
say the next month or two.
I feel very strongly about supervised visits. My reasoning for this is there's been a history of the substance abuse. There's been domestic violence in our relationship, negligence towards the children. I would love supervised visits every other weekend. My reasoning for this is he's always been supervised. I have been the primary parent since the day my children were born. He trusted me to be the stay-at-home mom with our children. He trusted me for 5 years to do that. I don't see why anything should change now. Also, Samuel allowed for him 30 minutes, maybe a day, to spend with the children and be available to them. He would spend 2 hours at the gym and come home and have 30 minutes while he was packing his lunch and eating his breakfast and showering, that he was available to the children. I added that up over 2 weeks. That is 7 hours every 2 weeks. So I feel very strongly about supervised visits every other
Who would
week.
you have be the supervisor?
I'm comfortable with his sister, Angela.
All right, Mr. Mills, I'd like to hear your response.
So the steroids, that was a mistake I've made in the past. I haven't steroids, and she said she thinks she found a novelty sticker. I believe there's photos included of that. The novelty sticker on it says 1 gallon. You're supposed to put it on a water jug and drink out of it as a joke. A friend gave it to me. And then she found a pill in a bag that was a painkiller, because I don't have health insurance. And one of the times when I was watching the children, they got hand, foot, mouth and gave it to me. And so I had lacerations on my tongue, mouth, throat, and I couldn't even drink water. It hurt so bad. So my dad gave me old painkillers. I took them for a day and a half until the laceration started to heal enough to where it was tolerable. And then I didn't finish them. And that was in the cupboard. But she's trusted me with the kids. She left me with the kids when all of us were sick, so she could go spend time with her new boyfriend that she met online. And she would be in and out. She had no problem leaving me with the kids while she was sleeping over there.
What time frame are we talking about?
December through January, up until February, when she went to my house and believed she found steroids and then decided to just not let me have my children, because we had a verbal agreement to be trading the kids every 5 days, and we had been following that. But I don't believe that Rebecca is emotionally stable. I believe she's bipolar. And on the day that happened, my mother was in the house before she started rummaging for things to try and make a case out of. I put new photos on the wall of me and my children, and my mother said she saw her look at them and could see rage in her face. And then as soon as my mother left, that's when she started digging to try and find any excuse to not let me see my kids. Oh, may I address?
If I ordered supervised visits for a short period of time, would your sister, would that work out with your sister?
She would be okay with that, but I don't believe that it's necessary, because Rebecca had no issue letting me have the kids for about 2 months. Like, just, we would be trading days. She had no issue with that. She did not treat me as if I was an unfit parent. She trusted me to do it all. And then now she's just trying to make sure that she has a case against me and makes me look as horrible as possible.
I did put in my reply the dates in January that I had the children. I feel like he is making it sound like, oh, I just left for 2 months. I had the children January 2nd through 5th, January 12th through 17th, January 22nd through the 26th of January. And in his motion, he claimed that I neglected them, that I left for 2 weeks. I was never gone for 2 weeks. I was
the children, the times you didn't have them.
What was that? Sorry.
Were the children with Mr. Mills when you did not have them?
Yes, they were.
Okay.
And they were with him until I found some things around the house that were very concerning.
And Your Honor, may I address?
Yeah, briefly, and then I'll tell you what I think we need to do at this point, but go ahead.
The 30 minutes a day thing isn't true. I would wake up before everybody and I would go to the gym. And then inevitably, while I was finishing up at the gym, everyone would wake up. I'd come home, I'd eat breakfast, I'd visit, I'd get ready to go to work. And then I'd go to work. But when I'd come home in the evening, I'd still be with my kids. I'd still bathe them. I'd still put them to bed. So that's just not true.
I typically will appoint a guardian ad litem to investigate the situation. So we need to do that in this case.
We already have one.
Oh, who is that?
I'm not sure, but I know that we have a date set for that already.
This is news to me, Your Honor.
I don't think it's appointed in this case.
I've been served multiple papers. None of them mention a guardian ad litem, if anything.
That your mother filed.
Is there a GAL in another case?
There is not a GAL appointed. There's a motion to appoint a GAL.
Okay, there's a motion to appoint a GAL.
Oh, okay. Sorry.
Makes sense. I think that's where we need to go at this point.
Mm-hmm.
Right. So let's take care of that appointment right now. And then I want to tell you how we'll deal with visitation for at least 4 weeks going forward. Do any of you know any of those folks? Okay. So I'm going to appoint Tina Day. She will be reaching out to both of you At this point, I'm going to require that you both pay 1/2 of her fee. If you feel you can't afford that, you can file a financial declaration in this case, and I can consider whether to have the county pay part of the fee. 018308, then the family law matters. In the protection order case, there were concerning texts that basically amounted to threats. And based on that, I think supervised visits at this time make sense. I'm not saying that that's going to be the case forever. I'm not saying that anybody's a bad parent here. I'm just saying that those texts raise concerns for the court. So I'm going to order visitation. If I don't know what the sister's schedule is, if she can stay overnight with the children, then I'm okay with a Saturday to Sunday, say Saturday at 10 to Sunday at 6. If she can't stay overnight, then it's going to have to be just a daytime visit. But whenever the children are with Mr. Mills, until our next review date, the sister will need to be the supervisor.
Can I make a comment? She is a stay-at-home mother, and I am completely comfortable with the children spending the night there if she's open to it. And I don't care how late Samuel stays, as long as they're supervised by his sister.
Okay.
I'm open to it.
So you're okay with both the sister and the mother? Am I saying that right? You said,
No, not the mother. No.
you said there's a stay-at-home who?
His sister is a stay-at-home mom, so her availability is pretty open.
And they live together?
No.
They don't, okay. So where are you expecting these visitations to take place?
At her home is what I would like.
At her home overnight?
Yes, yes. If she's open to overnight, if not, the schedule is fine.
All right, I'm going to be a little more specific here. So if the sister is available and willing, then the visits can be Saturday at 10 to Sunday at 6.
Yes.
Okay. If the sister's not available, then I'm going to order, well, if she's not available for overnight, she still needs to be present.
Yes.
Your Honor, if I may.
Just a minute. Then I think we're looking at Saturday from 10 to 6 every other week. Go ahead, Mr. Mills.
I mean, my mother is competent and she is able to stay the night with me and supervise.
Absolutely not.
I'm at this point, I'm going to take the recommendation of Ms. Mills. Again, all of this can change once the guardian ad litem gets a chance to talk to everybody. But I'm going to take the recommendation of Ms. Mills at this point. So what about sometimes we allow telephone visits in between any, has there been any telephone or video visits?
He has not asked about them. He hasn't asked for a phone call. He hasn't asked for a photo. Our children have been sick off and on since Christmas. I mean, with one thing or another, I'm sure us splitting up has done a lot on their little immune systems. But I mean, he knew our son was sick and didn't check in once. I am open to a video call. I'm open to it, but I haven't seen an effort.
Your Honor.
Go ahead.
That's not true. I have texted her and I have proof of a text saying, please let me see my children. And it didn't go over well. And so I stopped asking, and that's why I'm here today, because asking causes fights. So
Okay.
I refrained from that.
All right. Well, I've ruled how I want the visits to go. I would like, I'll agree to one video visit a week. So there should be, every week, there should be a video visit.
Okay, about how
Are
long?
you able to communicate either by text or is there some protection order that prevents you from doing that?
I have a no contact order.
Let's go through the sister, I guess. And you can arrange video visits that way.
Okay.
Okay.
And then I
And
have,
let's have the first weekend of these visits, March 11th and 12th. And that will give everybody a chance to prepare for that.
That's the in-person.
In person with the sister overnight.
Did you say 11th and 12th?
11th, March 11th to Sunday the 12th.
Okay, thank you, Your
And
Honor.
then every other weekend. So the next one would be the 24th and 25th. I'd like to be back here on March 29th with everybody.
okay.
We're going to see how those visits have gone, and the guardian ad litem may not have all of her research done, but we may have some. So we can see what direction we're going to go. Okay.
Yeah.
Yes.
I have a question.
Oh, you have a hearing set, I guess, on April 15th to appoint a GAL on March 15th. So we're taking care of that now.
Okay, so don't show
So
up.
we're going to strike that hearing.
Thank you. I have a question.
Okay, briefly, yes.
About the visitation, are there any forms we have to fill out or filing that with the court or anything, or we just handle it on our own?
Yeah, handle it on your own. I'm going to do what's called a bench order, which will outline what I've ruled. If you need to come up and get a copy of that so that you have an order in your hand, that will be fine.
Okay.
All right. Okay. When Ms. Day contacts both of you, it's best to cooperate as much as you can. That helps the court out and we can move this forward as soon as possible. Okay.
Thank you.
All right. Thank you both. We'll see you back here on March 29th.
Thank you.
Mr. Huffine was present on February 22nd, and at that time, Your Honor had ordered that he report to jail at 5 p.m. on that same date. And we did later receive an email from the clerk's office stating that he had reported on the morning of February 23rd rather than on the evening as Your Honor had ordered, and that he had posted the $500 bail. So we will be sending over an order forfeiting bail for that amount so that it can be posted to his account. At this time, what the state would be requesting, Your Honor, is that Mr. Huffine provide documentation from his employer that shows proof of his employment, and that he provide a copy of the paperwork he stated he filled out when he was hired that shows the wage withholding would be put in place by his employer. And what we're also requesting today is that we amend his ongoing direct contempt order to include that if he in the future fails to pay and is ordered to report to jail, but fails to report to jail, that a bench warrant would be issued without further hearing. And we would like that to be an ongoing requirement for Mr. Huffine. At this time, his next payment will be due to be posted to his account by March 25th, and we would request his next review to be April 5th.
And how much is this payment amount?
His ongoing purge amount is $250, Your Honor. We requested the increase because he had missed 2 payments. So the $500 was for 2 of his regular payments because he had not made them.
So by, what was the March date again?
He has an ongoing order to have his payments posted by the 25th of each month. So it would be posted to his account by March 25th.
Are you expecting within what, $500 by the 25th?
$250, Your Honor. The $500 was a one-time bail at request because he had missed two of the $250 payments at that time.
Okay, I just wanted to make sure that was clear. Mr. Angelico?
I believe the order was $250, so Mr. Huffines realized that the $500 was for the 2 payments. That was, I think, outlined to him at the last hearing. So we have no objection to the fact that this goes to 4/5, that the payment be posted by 3/25, and that we'll try to get together with Mr. Fines to get the information that the prosecutor is asking for. I believe it was discussed at the, potentially part of it was discussed at the last hearing.
That's correct, Commissioner Angelica. We just have not received it yet, so we wanted to renew the request.
Mr. Huffine, I recall that
Hello, this is Hunter.
Hey, Hunter, this is Justin. How's that going?
Hunter, yeah, thank you.
Mr. Huffine, I recall I requested you provide the employment information to Ms. Looney before now. Is there a reason you haven't done that yet?
Oh, I just didn't get the paperwork over there. I mean, I had a lot going on this week.
You can submit it to my office, Your Honor, and we'll make sure Ms. Looney gets it as soon as we get it.
Okay, well, I want that done by the next court date, or that could itself be a reason to order some jail time, because there's been several requests for that to be done. When's his next hearing date?
He's required to come the first week of the month, so it would be April 5th, Your Honor.
All right, Mr. Huffine, you need to provide documentation of where you're working, including the initial paperwork that you did for your employer to Mr. Angelico.
And actually, it's I think that they're requesting the wage withholding.
Okay, yes.
It indicated he had signed something about having wages withheld, and if that's the case, I think that's what they're asking for a copy of.
So provide that documentation to Mr. Angelico.
Okay.
That if I should order that you go to jail in the future and you fail to appear, then a bench warrant would be issued automatically without having to come back and ask me for it.
Okay.
Okay, we'll see you. Thank you. I see Mr. Rosales is with us now.